Meanwhile, the St. Louis County Prosecutor's office says it will start presenting evidence to a grand jury this morning. That process could lead to criminal charges against the officer who shot Michael Brown. CBS News legal analyst Jack Ford is with us. Jack, good morning.
Good morning, Nora.
All right, grand jury, evidence being presented. What do you think will happen?
Well, what happens is this. The grand jury consists of 12 people, and grand jurors listen to basically one side of a case, although the police officer has been invited to come and testify if he chooses to. At the end of that, you have to remember, a grand jury is not a trial jury. They don't decide guilty or not guilty. All they decide is there probable cause to believe that a crime has been committed and that this defendant was involved in it? If they say yes, if 9 of 12 of them say yes, then charges are filed, and then it would move on to the trial process. It's going to take probably a couple of weeks. They're going to be very careful and deliberate about this. But you know what? You don't know what's going to come out of this because we still don't know what each side has in terms of facts.
Mm-hmm. New York Times is reporting Officer Wilson sustained an injury during this struggle in the car. How does that potentially impact the case?
Well, what it does is it gives some hard evidence for the police officer to justify his position, saying, look, I was defending myself. Because remember, the defense is self-defense. I mean, the shooting took place and the young man tragically died. Question is whether he should be criminally responsible. We go back to George Zimmerman. Remember, George Zimmerman very quickly showed the damage, the injuries that he had to his head in the confrontation with Trayvon Martin. That became very significant, ultimately, for jurors when they decided that it was indeed self-defense. So does this mean, yes, indeed, self-defense will prevail? No, but it does give the police officer something to point to in terms of physical facts.
I'm curious to hear how you would argue on behalf of the police officer. You keep saying self-defense. Is it a defense? We read an article this morning in the Washington Post, an op-ed, where an officer wrote in and said, if I'm a cop, if you don't want to get hurt, don't challenge me. And I think a lot of people are wondering, is that a reasonable defense? You know,
when you talk about self-defense, obviously it depends upon the facts of the circumstance here. There's no doubt that the shooting took place, no doubt that, as we said, that the man died. The question is, well, what prompted it? Was the young man the aggressor and the police officer had to act in self-defense? If that's the case, then he has something they can argue. It'll be interesting to see whether he will testify in front of the grand jury. He's given that ability. At some point in time, your defense is self-defense. You're going to have to tell your story in some fashion or other. So the decision for his lawyer might be, do we tell it sooner rather than later, in the hopes of, if the grand jury accepts what he's saying and does believe he acted in self-defense, there might be no charges coming out of this? Or do you wait, if you get indicted, tell your story at a trial and try and convince a jury? Again, the standard is different, standard of proof is different there. But so one of the big issues here is going to be, when will we hear from the police officer as he offers up this defense of self-defense?
Jack Ford, fascinating discussion. Thank you very much.